are on application of Cobalt Data Centre 2 LLP and another against the Commission for His Majesty's Revenue and Customs.
Yes, Monsieur.
Good morning, everyone. Can I then take you straight to section 298 of the Capital Allowances Act 2001, which is on page 1058, the authorities.
Yes.
Now, the Upper Tribunal and the Court of Appeal both construed this provision so that the term contract in subsection 1b meant any contract. You'll have seen that when looking at what the Court of Appeal said yesterday. Until yesterday, I had understood that to be the appellant's position. However, my learned friend realistically conceded yesterday that the contract referred to there had to be impliedly limited. Otherwise, there would be absurdity if it could be any contract entered into in the 10-year period. I understood his limitation to be that the contract entered into in the 10-year period had to be a contract to construct a building in an enterprise zone. I think he said any building, and I think he said any enterprise zone. I may be wrong about that. He did not explain where that limitation came from in the statutory language. It was simply a matter of, I think, there had to be a limitation, and that was the one which he put forward. So the central question in this issue is, therefore, now whether a contract in section 2981B means a contract to construct any building in any enterprise zone, or whether it must be a contract for the construction of the building referred to in the opening words of section 2981, where it talks about expenditure on the construction of a building on a site in an enterprise zone. Now, the purpose of the EZA provisions was to make a significant impact by way of new development, improvement of existing property, or increased economic activity within a reasonable timescale. And we can see this set out clearly in the budget press release, which is, you'll find the relevant part on page 3114 of the authorities. And it's particularly paragraph 4 at the bottom of page 3114. And you will see the second, if we start in the second sentence, he, that's the Secretary of State for the Environment, will agree with the appropriate authority the planning proposals and policies of the area, as well as administrative arrangements for ensuring quick determination of planning and building applications. The Secretary of State would then designate the area. The designation order will be put before Parliament before going into force. Since the aim of setting up an enterprise zone is to achieve a significant impact by way of new development, improvement of existing property, or increased economic activity within a reasonable timescale, the Government proposes that the designation orders should run for a period of 10 years. Designation will bring into effect the fiscal and other measures listed below. And then you can see in paragraph 5 all the various advantages of being in an enterprise zone, including exemption from development land tax, then the capital allowances, and then rates, simplification of planning procedures, exclusion from industrial training boards, etc. You can see all of those. Now, all of those only apply during the 10-year period. There is a transitional provision. I'm afraid it's not in the bundle in relation to development land tax. Land tax was a tax on the disposal of land which had development value. It's long since abolished, but it was in existence at that time. What that said was that it applied to contracts, disposals under contracts entered into within the 10-year period. So if you had already contracted to dispose of it, then you got the exemption, even if the disposal actually took place after the end of the the period. Now, at that time, when the legislation was introduced in 1980, there was the 10-year period, and there was the provision for the contract, under a contract entered into within the 10-year period, but there was no further restriction. The 20-year period didn't exist at that stage. So if you entered into a contract within the period, there was no limit on the time which you could incur expenditure under that contract. It was in 1992 when the 20-year long stop period was introduced. So that's why there is only a reference to the 10-year period in this press release. And I would submit, contrary to what my learned friend suggested, that the purpose of the enterprise zones was to be achieved by the 10-year limitation, not by the 20-year long stop that was subsequently imposed. Now, the purpose, we would say, of the extension...
Well, it's a 10-year expenditure or a contract entered into within the 10 years.
Yes, but at that point, if you entered into the contract within the 10 years and you incurred expenditure, you could incur it 30 years after, theoretically, because there was no...
So that was then cut back?
Limitation.
That was then cut back?
That was cut back in 1992, yes. So the provisions were introduced in 1980 to begin with, and the 20-year long stop was introduced in 1992.
Yes, but before 1992, could the expenditure be at any time, or did it have to be within the 10 years?
No, the expenditure had to be incurred within the 10 years,
yes,
or under a contract entered into within the 10 years.
Oh, I see.
But outside the 10 years.
Okay, so it could actually be any time, providing you contracted for it within the 10
exactly.
years.
Exactly. That's what my point, Mike. At that time,
in Section 5, explaining what it means to incur expenditure, that was in the original.
Yes, that's always been there. So there is, you may have noticed in Section 5, even if you've unconditionally agreed to incur the expenditure, if you don't incur it for 4 months, then the time at which you're treated as incurring it is the actual time when you incur it, when you actually pay it. Sorry, when you pay it rather. If you the normal rule is that expenditure is incurred when you are unconditionally obliged to incur it under Section 5. But if you don't actually pay it within 4 months of unconditionally incurring it, then the time at which you are treated as incurring it is when you pay it subsequently.
Is that in Section 5? That's
Section 5. It is Section 5, subsection 5.
Do you have a page number for section?
Yes. Section 5 is on 1050.
1050.
1050.
Thank you.
And subsection 5 is on 1051. So if you have a building contract, although you...
So you can't within the 10 years say, I unconditionally promise to pay you £1 million in 30 years' time. You've actually got to pay it within 4 months.
Yeah, yes, that's right. So that's why, although they may have, under the contract to build the building, they may have unconditionally agreed to pay for it, it may not have to be paid till more than 4 months after, because it would normally be paid in stages, as you know, under building contracts. So you enter into the contract in year 9, you're unconditionally obliged to pay all the work, but you don't actually have to pay it until the work is being done in stages. So you may have to pay it in year 11, year 12, whatever. And the expenditure is treated as incurred in year 11 and year 12, not in year 9.
But that's okay if that's in the 20-year...
Exactly, yes. But that's one of the reasons why you have this extension for contracts entered into within the period, because you may incur expenditure under those contracts after the end of the period. So we say the purpose of this is to allow
How do we get
buildings...
up to? How do we get beyond 4 months then? I'm just. How do we get to year 16? A contract entered into within 10 years,
Yeah. So you've...
and the expenditure has to be within 20 years.
Yeah.
So
Incurred within 20 years. Yeah.
incurred.
Yeah.
Yeah. Sorry, how does that? I may have missed this, but how does that relate to the point you're making about the 4 months?
Well, under the contract, you will have unconditionally agreed to pay for the entire building, but you won't have to pay immediately. You'll have to pay in stages. And what subsection 5 is saying is an agreement amount is not required to be paid until a date later than 4 months. So under a building contract, you wouldn't be required to pay until, for instance, you got a certificate from whatever that stage 1 had been built, etc. So if that, in those situations, the expenditure is treated as incurred when you actually pay it subsequently. That's
Or when you actually commit to paying.
no, when you actually pay it.
I mean, under a normal building contract, would you have an unconditional obligation to pay stage payments before a certificate is issued?
You may or may not, but
It'd be unlikely, wouldn't it?
yes. If you don't, then there's no problem at all. The reason for the extension is quite obvious, that you will be incurring the expenditure after the 10-year period, even though you've entered into the contract during the 10-year period.
But you may have a period of time in which you are given a period of time after the certificate comes through which triggers the obligation to pay, and you then may have however long to pay, and here it's saying it mustn't be more than 4 months.
If it's more than 4 months, then it's...
I don't think it's saying it mustn't be more than 4 months. It's saying if it is more than 4 months,
Yeah.
you postpone the date when
Exactly.
you're deemed to have incurred the expenditure.
Exactly.
Yeah.
So it may slip over 20 years.
But it depends.
Yes.
I mean,
Depends, yeah.
But you have to meet the 20-year
Yes.
timetable, including under this
Yes.
postponement provision as well.
Yes.
But I think you told me that before 1992, providing you had your contract within 10 years, you could incur the expenditure any time thereafter.
Yes.
It would still be
There's no
recoverable.
long stop.
So why did they need all this in Section 5 before 1992 if there wasn't a long stop deadline which you might miss as a result of the operation of
Section
subsection
5 Section 5 is a general provision about capital allowances. It doesn't just...
Oh, I see. So it's not aimed at this at all.
It's giving you the date on which you treat it as incurring expenditure for
Right.
all purposes of capital allowances.
Right, understood.
Yeah. I mean, it's to stop you bringing forward, as my lady has suggested, bringing forward the date when you can claim your capital allowances by unconditionally agreeing to pay, but not being obliged to pay for more than 4 months. And that's the purpose of the provision.
Right, thank you.
Yes, it's not limited to. But the purpose of the extension, we say, the provision which allows expenditure incurred after the 10-year period, but under a contract entered into during it, is to allow buildings to be built or completed after the 10-year period when they were contracted for before. That's what we say is the purpose of it. And we say the time at which the contract has to be entered into, although it's worded slightly differently in the 1990 Act and the 2001 Act, the effect is in fact the same. If we can just look, de bene esse at least, at the 1990 Act, it's page 1045. It's subsection 1B. The expenditure is incurred or is incurred under a contract entered into. So we can read it that the expenditure is incurred under a contract entered into at a time when the site of the industrial building or structure is in an enterprise zone. And the industrial building is a reference to the industrial building in subsection in 1A. Person incurs capital expenditure on the construction of a building or a structure which is to be an industrial building or structure. And then being a time not more than 10 years after the site, that's the site of the industrial building, was first included in the zone. So what you can see there clearly is that the timing is linked to the whether the site of the industrial building or the putative industrial building at that stage was in the enterprise zone at the time of the contract.
So you're emphasising the site.
I'm emphasising the fact
and
that
the enterprise zone.
I'm emphasising here the fact that the way that the timing rule is applied links. It doesn't just ask you whether the contract was entered into within 10 years of the site being the zone being designated. It actually specifically refers to at the time of the contract, the site of the building that is to be built is in the enterprise zone. And the question you might ask is, well, why are we interested in whether the site of the building, which is on which the expenditure is to be incurred, is in the enterprise zone at the time of the contract, unless that is the building we're talking about, that the contract is referring to?
Well, you might say that sounds if I might say so, a good argument in relation perhaps to site and enterprise zone. I'm not sure at the moment I see why it has to be related to the building.
Because it is the
whole idea is we're getting sites in enterprise zones being developed.
But it's a site, but it has to be the site of the building. It's not any site. It's the site of the building, which is to be constructed. So you're asking the question at the time of the contract, is the site of the building on which the expenditure is to be incurred in the enterprise zone? Now, my learned friend says it doesn't matter about that building. The contract could be about something completely different. It could be about another building in another enterprise zone. And we say that doesn't make any sense of this structure of this provision.
I have to say, I didn't understand the point that you started off with today, that Mr. Rabinovich was actually saying it could be on any enterprise zone or any site. It may have been that's what he was saying, but I didn't understand him to be saying that.
It can't be. He can't be saying it's the building on the very site, because the contract was not for that building. He says it has to be a contract for a building in an enterprise zone, but not necessarily this building. Not necessarily the building that was actually constructed.
It's always going to be in this enterprise zone.
Well, not necessarily. You could have a contract to build a building in a different enterprise zone.
Yeah, but that's not being argued, I don't think, is it?
I don't know. I understood at some stage you were saying
that. You've got to find an interpretation, presumably, that doesn't fit his facts, which is that the building there was always going to be a building in this enterprise zone.
Yes.
That's what they built.
But what I'm addressing is what is the limitation on the contract that has to be entered into within the 10 years?
Well, say the limitation, going back to the history, and of course you are saying the Bene Essay in relation to all.
Yeah, I was going to take you to the 2001 Act in a moment.
Yeah. Let's say that there's a restriction about the site and the enterprise zone, which I can sort of understand. It might be said on the facts of this case, we've got the same enterprise zone and all these buildings are on site A.
But the building is not on the site.
Not site C, but it's all within site A.
Oh, right.
Which is within the umbrella golden contract.
Yes.
So we've got the same site and we've got the same enterprise zone.
Site A is not a relevant site for any of the options that have been chosen or anything.
Well, clearly it's not, because there's already a building there.
Well,
but site C the argument being put against you, I think, is that there's been a variation, so that option 1 effectively includes another building on site A.
Yes. I think that we may be moving to a different issue. I mean, what I'm addressing here is a simple point of construction as to which contract they're referring to in, if we go back to the 2001 Act, they're referring to in sub B.
But
2981. Is it the contract? Is it a contract for to build to construct the building that you're actually claiming allowances for, or could it be a contract for another building? That's the issue that I'm addressing.
You keep jumping between building and site.
yes.
But are you saying that it matters? I mean, all the sites which have been built on in this case are sites within an enterprise zone, this particular enterprise zone
Yes.
in the north. But are you saying that the building has to be on the same bit of the enterprise zone as was contracted for?
It has to be. Yes, the contract has to be for the same building on the same site. Yes.
Well, let's just stick to the site for a
Yeah.
minute. So you're saying you have a building, it's in a small part within an enterprise zone, and they decide actually that land we find is contaminated or not suitable for somebody else, it's more suitable for somebody else, so we'll build our building in a different part of this enterprise zone. You're saying that wouldn't be covered then? You can't change the site within the enterprise zone?
So they've entered into a contract with a contractor to construct a building on site X, let's say.
Yes.
And then they decide they can't, for some reason, do it on site X, so they're going to do it on site, change the contract so they're doing it on site Y.
All within the same enterprise zone?
Yes. We would say that's, well, if they do that after the 10-year period, then that wouldn't be the same contract for building the same building on the same site. No.
But just so I'm clear about this, if they hadn't amended the 1990 Act, we could be looking 50 years down the road and asking whether 50 years ago the building on which the capital expenditure has just been made, just been incurred within the meaning of Section 5, was either itself, is now on a site which was then within an enterprise zone, or whether the expenditure was incurred under a contract entered into at that time, namely at a time when the site was within the enterprise zone and the 10-year limit hadn't run out.
Yes, you'd have to ask that question, but then you'd have to ask, assuming we've now got some development construction taking place under a contract, you have to ask whether that is the contract that was entered into a 10-year period.
But then you have to look rather closely at what the words under a contract mean in relation to contract. So you have to ask whether that imports a requirement that the contract is that which provides contractual force for the incurring of the expenditure. I think that's common ground, but then you would add, and it also has to provide for the building of this building.
Yes, exactly, yes. Because
that's really meaning that's looking at what under a means, isn't it?
Well, it's looking at maybe yes, under a contract. Well, there has to be a contract. I think everyone agrees within the 10-year period.
Absolutely,
there has to be a contract. As I said, up till now, it's been said it could be any contract at all. But now, I think it's agreed that it can't be any contract. There has to be some limitation on the contract. So, what contract can it be? So the question is, can it be a contract to build a different building, somewhere else on...
But on the same site. let's say.
Let's say on the same site, yes, a different building on the same site. Let's start with that.
Between sites.
Can it be a different building? So different expenditure. So you've contracted for expenditure on one building. You now subsequently incurring different expenditure on a different building. Does that qualify? And we say no, it doesn't.
So DC1 is out.
So well, I think on this basis all of them are out. DC1, DC2, and DC3.
So you say DC1 is out because it's a different building.
Yes, we say that this is fundamentally flawed. The scheme is based on the premise that you could have any contract, I think, but it's flawed in that way. Yeah, that's we would say that's not what this provision provides for. So all of them, yeah, exactly. It's simply you cannot use a contract for something else, building something else, and turn it into a contract to build.
What becomes something else? What becomes something else? On your view?
Well, it's whether it's the same.
I mean, we're told that the words are under a contract. So you might think, well, what the legislature has done, it's not actually, although you showed us the history and made an argument about the history, I have to say I think that history, speaking for myself, is somewhat ambiguous and doesn't really answer our question. But they've chosen to use the words under a contract. So you might say, well, what the legislature's done is to leave it to the common law concept of what is meant by under a contract. And so the question we have to ask is the new building, on your phrase, new building, under a contract? Was the expenditure on that?
Well, it certainly is
under a contract. And then we come back, don't we, to issues 2 and 3.
Well, no, because the contract has to be entered into within 10 years.
Yes.
So, but that then raises the question. I think what the Lordship was suggesting is it could be any contract, as long as it can be turned into, as long as it can be varied and remain the same contract, then it could be any contract.
Well, isn't your point?
Well, that's what the legislature's done.
Well, that does mean that you could have a sale, as I think my learned friends recognised. If that's right, you could have any kind of a sale of goods contract which you can turn into by variation.
It seems to me at the moment that the question is, given that Parliament has seen fit to limit it to contracts entered into within the 10 years, expenditure has to be a contract entered into within the 10 years. And we know that the common law principles say that a variation takes effect for some purposes, we discussed yesterday, not all purposes, as making the contract different, but it's still got the same start date, the contract. It's just varied. It seems to me the question is if the expenditure is committed to under those varied provisions, which didn't exist in the original contract, is it still expenditure incurred under a contract entered into within the 10 years?
Well,
I mean, that may be where you would say, regardless of the fact that the common law principles backdate the variation and treat it as having been always there for some purposes, that can't be what is meant by under a contract entered into. That can't mean that it's entered into for this purpose, because then the time limit just doesn't bite, because you can just vary it at any stage.
I think that would almost come to the same thing, though, because what your leadership would be saying was it has to be a contract for the same building. Otherwise, if it's a contract for something else that's been varied, then it wouldn't count. Seems to be just another way of getting to the same result.
Well, it may be, but we have to find a way of getting to the result. We have to
Yes.
make a reasoned decision.
Yes.
Let's assume, I mean, your example of the sale of goods, I'm not sure I follow that, because I think the parameters are we've got to have a site, a building contract on a site in an enterprise zone.
Well,
it seems to me within the context of that's the sort of contract we're talking about.
If you're getting that from the statute, then we're not talking about any building contract or any building or any site. We're talking about the building on the site. That's what the statute talks about. Oh. And it asks the question, and I go back to this, it asks the question whether at the time of the contract, which is in the 10-year period, the building that you constructed was on a site in an enterprise zone. So I would suggest that is, you would draw from that the conclusion that the contract you're talking about must be a contract for the construction of that building. Why on earth otherwise would you be asking this question about whether that building, that building was on a site in an enterprise zone at the time of the contract, if it didn't matter that it was a contract for some other building somewhere else?
Can I just test it this way? Suppose what the parties did was that they made a master agreement between each other, rather like a sort of ISDA master agreement for derivatives, which effectively said we want to be in a profitable developer-building contractor relationship for the next 20 years, and we hereby agree that, subject to deciding at a later stage to do something differently, every time we ask you to build a building and you agree to build it, it will be on the terms of this master agreement, which will incorporate the JCT standard form. It will have the usual arbitration provisions, time for payment, all the sort of detailed nitty-gritty you need to make a building contract work, but it won't say anything about buildings. And then what we will do is we will from time to time agree or not agree to bring a particular building project on a particular site within this master agreement. There are certain similarities between that and the Golden Contract, but just treat it as a master agreement. Now, literally speaking, if the expenditure is incurred on a building which was at the material time within the enterprise zone.
Happens to be, yeah, exactly.
And it's incurred, in a sense, under the master agreement, because that's how the relationship works. Everything's done under the master agreement. You could say that literally subparagraph 1B of the 1990 Act was satisfied, couldn't you? Because you look at the contracts and say, well, is it done under this contract? Yes, it's done under this master agreement. Is the contract entered into at a relevant time? Answer, yes, because it was within 10 years of the creation of the zone, and the building on which you've actually spent the money is on a site which is within that zone. Because it's a master agreement which is completely non-building specific.
I think then we would get into the question which was raised in the upper tribunal about an agreement to agree. That would essentially, the master agreement would be an agreement that we will agree particular, that we will encourage expenditure. You haven't agreed to incur the expenditure under that master agreement. You've not committed yourself to anything at all. I mean,
well, I think what I'm asking is whether if literally that would come within the language, would it serve a purposive interpretation of the language?
Well, it clearly shouldn't come within the language, because it clearly would not be within what is envisaged by this legislation.
But if you just have a master agreement in the sense that A and B agree that as and when they buy and sell derivatives, it will be on the terms of the ISDA master agreement, there's no contract other than, at stage one, other than when we do buy and sell, it'll be on the terms of the ISDA master agreement. So the relevant contract would not be until they agree to buy and sell.
Yeah.
I mean, I think that the ISDA master agreement in question here would be a rather unusual agreement, probably. I mean,
yes.
One would need to look at it
yes.
carefully. But here, of course, this contract provided, as I understand it, obliged the contractor to build one of works 1 to 6, or 1 and 3, or 2 and 3.
It did, but what the appellants the appellant's case comes to is that it's in effect like a master agreement, because you can turn it into anything.
Well, it's a sort of call-off agreement, really.
Sorry?
It's a call-off agreement rather than a master agreement. We agree that we will, and I think they also, the employer under this contract, did commit to building a building. They couldn't have just let the contract go. And
I understand that they committed to build one of the buildings,
Yeah.
or to opt for one of the 6
Yeah.
options. And if they had done that, then we would be in a different situation. But what they're saying is that they don't have to choose any of those 6. They can choose anything. In fact, they might have well have said, we can compel you to build anything we like, or we can agree to change this contract to build anything. So commercially, it comes down to the same as a master agreement, essentially, because they can agree whatever they like. And
But your essential proposition is resting on it's got to be the same building.
it's got to be a contract to construct the same building that you are claiming allowances on in respect of. Exactly. And I would submit that anyone reading this, being told that you're claiming allowances on constructing a building, you're asking the question, was the building in an enterprise zone at the time of the contract? If you ask them, what is this a contract for? They would say, of course it's a contract to build that building. That's what they're referring to. That's clearly what they're referring to. You don't need to read any words in. You just have to understand English, that this is what they're what this statute is referring to.
And what do we then do about pinpointing what's meant by the same building? Because how do we decide whether the data centre is the same building as the microchip building?
Well, my first answer to that is that kind of question is a question that's routinely determined by the courts, certainly by the tax courts. They're always asking questions about whether something is the same building or something's the same something or other.
Supposing you had
not an unusual question to ask.
But it's not what...
It'd be a matter of fact, really, whether it's the same building.
Right. But it's not very clear cut, is it, for people trying to rely on what the tax legislation lays down to be told, well, we're not sure what's meant by a same building, you're going to have to go off to a tribunal to sort that out.
Well, with respect, quite a lot of this legislation is not that. I mean, legislation in general, and you can't expect black and white rules, by which I mean rules that you can determine the answer yourself without any difficulty.
Which is why they've used the word contract entered into.
Well,
I mean, as I understand it, you're saying it's got to be under a contract for the same building. Is that right?
Yes.
They're the words we're reading in, under a contract for the same building. You might say, well, why haven't they said that?
Well, because we would submit it's pretty obvious.
So can I try another example? Supposing you have a contract whereby the contractor undertakes to build in the enterprise zone such factory or office block with values as certified by quantity surveyors up to £25 million as the developer shall require. Would that fit your test? Would that entitle the developer to the capital allowance?
Would that be a contract?
Well, why
to
not?
build that building? Could well be, yeah.
Because it's not the same building. It's not a contract for any specified building. It's a contract for such factory or office block up to a certain quantified value as is required. So you're not into any of this question. Is it a factory or a data center or something?
You might
not an obligation. The expenditure has been incurred. The contractor must build, and the developer must require the building to be built, but it's not specified beyond that.
And so they are obliged to build whatever they're told within certain parameters.
Yes.
Well, then I think you could certainly construe that as being the same.
Well, there isn't the same building. We don't get into that issue, do we? We don't get into the issue of the same building. I mean, I'm just testing your proposition that it has to be a contract for a specified building. I don't
Well, it has to be a
quite
contract.
see why that should be
I
said.
don't
in the
think I
language.
said it had to be specified. I said it had to be a contract for the same.
Well, I'm sorry.
For the same
if it's
building.
a contract, it has to be a contract for the same building.
Yes.
I assumed that meant that the contract specified the building.
Well, it wouldn't necessarily have to. I mean, the example that your lordship has
All right.
given, it wouldn't
Okay, well, I'm
have to specify it.
my example. Okay, that would attract capital allowance.
I think that.
I mean, assuming it's sufficiently certain and so on,
Yes.
as a contract.
Yeah.
That's the sort of clause 12 question, isn't it? I mean, I think you accept, don't you? But tell me if I've got this wrong. That if the appellants are right on clause 12, then they had a contractual right to require this building to be built under the golden contract, and it didn't require any fresh agreement to be made, then the golden contract qualified as a contract to build that building, even though it took a subsequent direction after the 10-year period expired to, if you like, crystallise it.
I think that would be right, assuming your answer. That assumes that
If they're right about clause 12,
Exactly, yeah.
of course.
But then, if you push that further, would you say that if they had a contractual right, that you would accept went as far as they say that clause 12 goes, which is that you could change the work options, would you then say it was entered into?
if they had a contractual clause that possibly could, yeah.
Well, it's all very well say possibly
That
could.
yeah. That would be the same. That would be.
So where they went wrong, you say, is on your basis, is that clause 12 doesn't go far enough. They had to vary the agreement, and the building and the site in the varied agreement is different from all the work options 1 to 6. And that's why it's...
Well, where they went wrong is not choosing one of the works options 1 to 6. Building that probably would have been the most straightforward thing to have done.
But you would say that if they exercised various contractual... Say they've got, as always happens with construction contracts, as we know, a number of contractual variations. Those contractual variations, do they then fall within the same building restriction that you're insisting on?
I'm sorry, I'm not... Could you...
So, as I understand it, you're pinning your main submission on the fact that this has to be a contract for the same building.
Yeah.
Let's assume we've got a building contract in which there are lots of variations permitted, including, for example, a different wing to a building, or so. Do you say, well, that's all fine, or we also have to ask the question whether it's for the same building? In other words, is it sufficient that you are making variations under the contract, under a contract clause? Is that sufficient, or do we have to ask?
Yes, because then you would have, the contract would be for the building that you actually built.
But it might not be.
It may have to be. There may have to be variations under the contract, but you're still contracting to build.
Okay, but that would imply to me that the crucial concept is not whether it's for the same building, but whether it's the same contract.
Yeah. Yes, I think that probably.
And then
Well,
I would say to you, what do you say about an express variation by consent of the contract by the parties? Is that the same contract, or are you saying that every express variation outside the contract?
I don't think I'm agreeing that it has to be the same. That it's enough that it's the same contract, because that would just take us back to it could be any contract at all.
Same contract on the site,
So the first
in the enterprise area.
right, yes.
I think, speaking for myself, they seem to be important qualifications throughout.
Yeah.
But what I'm really testing is whether it has to be the same building. As I understood your proposition, it is that it's got to be the same building, But what I'm querying is whether that is actually right and whether the real concept is whether it's the same contract.
I mean, before you answer, Mr. Ewan, I thought you'd accepted, in answer to my question, that it doesn't have to be for the same building. Mm. It's enough that there is a financial commitment.
Yes, exactly. Yes.
For construction on the enterprise zone, or on a site within an enterprise zone.
For that expenditure, yes.
For that expenditure.
Yeah.
Anyway, sorry.
Yes.
But I mean, supposing supposing you do have a contract for a particular building which has got a clause 12 type provision. I mean, I imagine it'd be common ground that any variation pursuant to clause 12, I mean, that would still be the expenditure under the original contract.
Yeah.
Yeah.
But how do you approach it when they say, well, we need to build an additional wing to this building, and that's doesn't fall within the terms of the equivalent of clause 12. we need the parties to agree to a contractual variation. How is the expenditure on the wing then treated if that contractual variation occurs after the expiry of the first 10 years?
Well, that wouldn't be expenditure. We would think that would be expenditure on the building you contracted for. That would be.
Well, no, because it's required a contractual variation. I'm sorry, a consensual variation.
Consensual variation.
A consensual variation to add the wing. So it's not done pursuant to a clause 12 type provision. It requires a consensual variation. How will that be dealt with?
Yes. That might bring you to issue 3, I guess. I suppose.
Well, how does it fit in under within the relevant section? 298.
Yeah. Well, the contract has still got to be a contract. The contract we're looking at has got to be a contract to construct the building. There is a contract to construct the building.
Yeah.
They have. Let's assume they've varied it so that it is, in some sense, the same contract. I think that's what you're assuming, and therefore it would qualify, assuming they've done that. I think that must.
Even after 10 years.
I have to say I'm completely confused by your submissions at the moment. I mean, I get the idea that you can have a contract entered into before the first 10-year period, which in effect creates an envelope within which a whole series of buildings might be built.
Yeah.
And that's what I rather took my Lord Richards to be putting to at the extreme end, where you don't even specify the options, you just specify the amount. We can build any building within the enterprise zone for such an amount, anything at all. And but there is a contractual obligation there.
Yeah.
And then you can move down to a situation much like the golden contract, where there's a series of options. So it's not any building at all. There are specified options, but there's still a contractual envelope within which the obligation arises, and that contractual envelope is created before the end of the 10-year period.
Yeah.
And I had understood up to that point that you were accepting, yes, if there's a contractual envelope and the building is within that contractual envelope and is within the enterprise zone, EZAs will be available. You now seem to be saying that even though the building is not within that contractual envelope specified before the 10-year period, but enters into the contractual obligation by a variation made after that period, still EZAs are available. I just want to check, is that what you're saying?
Yeah, I don't think that was what I was saying. If that was what I was understood, I think I would agree with
regroup.
I don't think I would be saying that. I think I would be saying it wouldn't fall within the expenditure that was contracted for during the 10-year period.
But take this example of new. So the contract is for a particular building. They're getting on with building that. In year 12, they decide to add a new wing to the building, an additional wing to the building. Thereafter, they continue incurring expenditure on the original building, and they're also incurring expenditure on the new wing. Does it sound a bizarre possibility that that's what happens? I'm, at the moment, not clear what your position is as to whether
My position?
all or none or part of all of that expenditure is covered, none of that expenditure is covered because the building's now got an extra wing and so it's a different kind of building, so they can't recover the expenditure on the original parts, or whether you say the expenditure incurred on the original plan of the building is fine, but the new wing is out because that's after 10 years.
Yes, I'm not saying that no expenditure is allowed because they build a wing onto something that they've built, which they've contracted for before. I'm not saying that. So they would be able to continue to qualify for relief on the expenditure on the building. What I am saying is that they shouldn't be able to qualify for expenditure on the wing which they've agreed to build afterwards, simply because it's a wing attached to a building that they've contracted for.
And what is it that... So if that's right, and at the moment seems potentially sensible outcome, it must be something, that must turn on something other than it having to be the same building, because it's not the same building, it's a building with in a different shape and size and whatever.
Well, by the same building, I didn't mean that it had to look the same. They have built the building they contracted for. They've just, on your example, they've just put something onto it.
Yeah.
So
It doesn't come to this, that it's the same building as contracted for.
yes.
So not necessarily, you're not necessarily looking, I don't know, at specifically physical characteristics of something that exists in the real world. You're looking at what the concept that the contract created as to what should be built, and saying, well, is it the same thing?
Yes, exactly.
Is that what you mean, the same building?
That's what I mean. I don't mean if they change the outside so it looks different, then they might say it's a different building.
Just so I can understand what answer you're arguing.
I am giving. Yes, I am saying.
Are you saying that EZAs are available in relation to such work as was done in respect of the original plan and the works that were required for that, but are not available in relation to the wing, which was added by a variation after the 10-year period?
Yes.
Is that what it comes down to?
That's exactly what I'm saying. And I'm saying that when I'm talking about it being incurred on the building, a contract to construct the building, I'm not suggesting that you look at it later on and say, well, it doesn't look like the same building that was contracted for.
So again, just so I can understand, when we go back to the sorts of contracts entered into within the initial 10-year period, which create an envelope of possible buildings, so moving from my Lord Richard's general example through to something like the the golden contract, where you have options. Again, are you accepting that as long as you have a building built within the parameters created by the contract for any of those buildings, and of course on the enterprise zone, that you can claim EZAs for those?
If they had, yes.
That's what I understood you to have accepted when we asked you about Clause 12, that you say, well, if they validly exercise Clause 12, then that's triggering a pre-existing, i.e. before the end of the first 10-year period, contractual obligation to build a building which is one of those options. That's how it would work.
And does it follow from that that the easy way to see whether expenditure falls within 2981B is to look to see what the original contract had, what the envelope created by the original contract was at the end of the 10-year period. I mean, there may be variations of the original contract that occur within the 10-year period. I mean, new contract variations, not a Clause 12 type situation. Clause 12 is all part of defining the envelope. But so you can look at all the amendments that are made contractually by a variation agreement up to the end of the 10-year period to see what the envelope is.
Yes.
But after that,
It wouldn't
any
matter.
later alteration is effectively if the capital expenditures are incurred under a movement of the envelope because of a later variation, it doesn't date back to the original date of the contract.
Yes, that's right. Because within a 10-year period, it wouldn't matter whether it was a variation of the original contract or a new contract, because
you just look at the end of the 10-year
it
period.
all qualify.
And one way or another, whether one's looking at the original and saying, well, that's as varied, or you're looking at the variation, which
As a contract.
is a contract itself, one way or the other, you've got a contractual obligation at that 10-year
Yes.
cut-off, if that's what it is.
Absolutely.
And you know what it is.
Yeah.
Yeah.
But I think you also then, you say, or I think what's put against you is that building contracts are always, in fact, an envelope, however closely they appear to be specified, because things change, technology changes, as Mr. Rabinovich says. So there is a boundary there, even where there can be expansions of the envelope even after the 10-year period, which you say you can still recover, you can still get the relief because it's still the same building.
It's within the contract.
It's within the contract.
Yeah.
You would say if it's a clause 12.1, then that's fine. It's not a change to the envelope. But anything beyond that is a change to the envelope once you've got past the 10 years. And that if there's a debate about which it is, that's the kind of thing the tribunal is always looking at. Is that roughly how it is?
Yes, that's right.
I mean, the problem I'm having here is I don't understand this concept of the envelope of a contract. I've never, ever heard this as a concept. If we were to apply it to this particular situation, are you saying that options 1 to 6 are within the envelope of the contract?
Yes, but they were obliged
So
to choose one of them.
anything within that is fine.
I think it might have been different if they hadn't been obliged to choose one.
But ultimately,
Then they wouldn't have been on the hook for anything.
ultimately, these buildings have been built on Site A within the enterprise zone. That is within the envelope of the contract, is it not?
This is you mean by Site A, you're talking about physically the entire...
I'm talking about Site A. Yeah, as I understand it, the buildings have all been built effectively.
We seem to be getting into what is meant by the envelope of the contract, and that may be my Lord Borough's point. It's a pretty uncertain concept, but I don't think the envelope of the contract is intended here by anyone to be used to mean the geographical area.
No.
I mean, I took the envelope of the contract here to mean the obligation on the contractor to build one of works 1 to 6, or 1 and 3, or 2 and 3, and the obligation of the developer to give a notice to proceed in respect of one of those.
But does it also include such further obligations as may be legitimately introduced by an instruction under clause 12? I think you say it does.
Yes, because those are the kind of variations that would not affect the envelope.
And I mean, it seems to me, if I may say so, that the lady must be right, that using this metaphor of envelope as just sort of saying where there's limits to contractual obligations on someone, it's likely that there will be an envelope which extends beyond the 10-year period for most building contracts for dealing with moderately minor details that need to be changed as the development proceeds, where there is a contractual obligation defined in the contract precisely to allow a degree of variation within the bounds and scope of that contract as formulated.
And that in this case is clause 12, as I understand it, which is a fairly standard JCT form, though it's been tweaked a bit.
Yes. And we say relatively limited in its scope.
Yeah, and there may be other more minor parts of the contract or parts of the project governed by contractual terms which give a degree of choice to the developer and also impose correspondingly obligations on the contractor to accept the choice as may be exercised by the developer as you move through time.
Yes. Well, as we may see later on, when you look at the sale and development agreement here, which sets out the framework for the development, there's a whole process they have to go through to try and find subcontractors and etc.
But just to be clear, so that I can follow what the implications are to the answer that I understood you to be giving to my lady, as I understand it, you accept that even if a choice within the boundaries specified by the contract is made after the 10-year cut-off, you're still within the contract, which has already defined the obligation of the contractor, and EZAs associated or flown from that choice would be available.
Absolutely, yes.
Right, okay.
Mr. Hughes, at some stage, I know we're barraging you with questions, but it would certainly help me to work out which of the possible meanings of section 2981B is the right one, to have your submissions of what the purpose of it all is.
Right, yes.
And in particular, the purpose of the not so much the, well, you may want to talk about the purpose for which these capital allowances are given, but also the purpose of the restraints imposed by the 10-year and the 20-year rule.
Right. Well, that was why I took you, sorry, my lord, to the budget.
I'm sorry, just before you do that,
yeah.
I've been looking at the site plan, sorry, because it's been left, at page 978.
Yeah.
Is that not correct?
Yep, that's the...
Right.
Yeah.
So just to be clear, as I'm understanding it, the green is showing site A.
Yeah, that's
So
right.
effectively the three buildings are within that, very marginal.
Yeah.
Oh, yeah.
Yeah.
Thank you very
Yeah,
much.
that's right.
That's all I was
Yeah.
just
Which
anxious.
is the green the enterprise zone, or is the blue the enterprise zone?
No, the enterprise zone is white. It's bigger, much bigger than this. The blue is the entire Siemens. It says site.
Entire what?
Siemens side. If you look on the right-hand side, there's a key.
Oh, I see. I've just.
So
You're saying that there's a sort of even bigger area.
Oh yes, there's a lot more. I think my friend, gave you some useful evidence yesterday as to the extent of the area.
Yeah, that's much better.
Because Siemens was on the site before it was an enterprise zone, is that right?
Exactly.
And they then said we're stopping production here, and it was created it was made an enterprise zone to promote development of the site being vacated by Siemens. Is that right?
Well, I'm not quite. I couldn't confirm that history exactly.
All right.
But, my understanding is it's bigger than this area, but.
I see. Right. Oh, I see. So the whole enterprise zone is larger than the Siemens site.
This bit.
Right.
Sorry, my lord. On the purpose, etc. That is why I took you to what was said in the press release, which was making it clear that the purpose was to stimulate as quickly as possible economic. They talk about achieving a significant impact by way of new development, improvement of existing property, or increased economic activity within a reasonable timescale. So they then say the government proposes the designation order should run. Because of that, they propose that the designation order should run for 10 years. So the purpose of the 10-year limit was to say you've got this very, very beneficial regime, not just in tax, but other things, planning, etc., for this 10-year period. And you've got to get on, they want to be able to get on with it and to do things within that period, not to do things 20 years later.
But you don't actually have to have broken ground within the 10-year period. I mean, here we know that I think the golden contract was entered on the last day, but that's fine. You don't actually have built anything.
No. You don't have to. A line has to be drawn somewhere, and the line was drawn at 10 years, and contracts that were entered into within the 10 years. And the purpose, we would say, the purpose of the contracts that are entered into extension is that people will enter into contracts, be committed to expenditure, but then won't incur it within the 10-year period. And it was felt that they shouldn't lose their allowances because of that. We would say that's simply the purpose of it. It wasn't specifically, it wouldn't be primarily designed to allow people to enter into contracts on the last day, but of course they can under the legislation. That's where the line has been drawn. But it's not the primary. I wouldn't suggest the purpose of this was to encourage people to wait till the end of the period and enter into contracts for development. And of course, all of the other stuff would go. For instance, the planning. If you were doing the development after the 10-year period, you would be back in the normal planning regime, not in the the simplified and improved planning system they had within the 10-year period.
Can I just ask about the press release? Was that released at the time of the 1980 budget?
Yeah.
Yeah, I think that's right. 26th March 1980. So that normally when the budgets were.
Okay. So I mean, there's no doubt that this is the announcement of government policy in effect, which
absolutely
for the reasons of confidentiality in relation to the budgets and so on, you just bring it in.
Yes. Yeah, they wouldn't announce it before.
That's right. Yes, right.
In those days, certainly. And so there has to be a line drawn somewhere. I think you can of course say, as my learned friend says, well, it's terribly unfair that after the end of the period they might decide that technology has moved on and they want to build something different. But that's just, I'm afraid, the 10-year period was set for good policy reasons. There was an extension if you were continuing to build on a contract, but it wasn't intended that you could be able to change your mind after the period, even if technology moved on or whatever. I don't imagine in 1980 they were envisaging the pace of change of technology that we have now.
So I think you said all the sort of simplified planning regime would come to an end after the 10 years, even after the even after the 2001 Act was passed. It didn't change the point at which the simplified planning regime came to an end.
I don't think I haven't checked all that, but I don't think that it changed. I think it was all within the 10-year period.
For each, so did that apply to each?
For all of these benefits.
Yes, but did each enterprise zone have its own 10-year period of simplified planning?
Yeah, well, each of them, they would start on a certain date, which would be different. But it could be different for each one. You have a 10-year period from the date of designation.
For the simplified planning?
For everything.
For everything.
Yeah. So this one ran from 1996 to 2006. But of course there were zones earlier than that because it was introduced in 1980. So each zone would get its designation at a particular time and then it would run for 10 years. I think they talk about, if you look in paragraph 3 of this, they're consulting about possible sites, proposing various sites in England and Scotland and Wales. Of course, at this stage, it was a kind of experiment, I think you described it. There is a bit of background in paragraph 2 as to what they were envisaging. Areas with problems of economic and physical decay.
Sorry, there are a number of different paragraph numberings in this. Which page?
I'm sorry, this is page 3114, paragraph 2. This is still the press release. Yes, sorry, 3114.
Right. Just to note, in fact, the announcement of enterprise zones begins on 3113.
Yeah.
That's where the sort of the policy is introduced, and then you move down to slightly more detail about the proposals, I think.
Yes. Though there's quite a lot of repetition.
But
yeah.
Just to get the structure of this document.
Yes, yeah. Yes, they list all the benefits twice, although in slightly more detail the second time. So we say a limited construction of section 298(1)(b along the lines that we suggest is entirely in line with the policy, which is not that these things should drag on for years and years, but they should be, in principle, happening speedily. Unless there are any more questions on the construction, I was going to move on to clause 12.
Do you want them to deal with the procedural thing on the entitled to Yes. I mean, at some point, Mr. Hewitt, unless you want just us to rely on what you've said in writing, there's the point about whether you can run this point at all.
Oh, right, yes.
To be dealt with. Entirely up to you when you deal with it, or whether you leave it to writing. But don't forget it.
Yes.
Because we are taking it as written by your opponent because he didn't have time to develop it orally.
Well, we have dealt with it in writing in our case.
Yes, you do.
I mean, the central point, I think, is a question of law. It's a question that was actually raised before the upper tribunal and it was argued before the Court of Appeal. An objection of some sort was taken before the Court of Appeal, you've seen, and the Court of Appeal decided to decide the question.
Yes, as best I understood what the Court of Appeal said, the objection was as the ambit of the permission that you had been given to appeal from the upper tribunal. And Lord Justice Lewison said this point fell within the ambit of that permission to appeal. That seemed to be a rather different point from whether it had been argued at all at first instance.
Or whether we were able to argue it in the Court of Appeal.
Well, obviously, if you didn't have permission, you wouldn't be able
to. No, but even if we have permission.
There are two things.
There are two issues.
One is, did you argue it before the upper tribunal? As I understand it, you're saying yes.
Yes.
Then you get permission from the Court of Appeal. There's then a question, is that point, which you did argue before the upper tribunal, available for argument under your permission? And the answer given was yes.
Yes, but there is a further point, of course, even if you have permission, the court, there's still an issue as to whether you're allowed to run a new point. Because having permission doesn't necessarily mean that you can run it. The court can say, well, you've been given permission, but we don't think you can run it on case management grounds.
I thought the point was, is this construction point contrary to your concession that this case needs to be decided on pure contractual principles?
Yes.
And that they say, well, if we knew that they were actually not going to decide this or argue it shouldn't be decided on pure contractual principles, but they were going to focus on statutory interpretation, then we would have presented different arguments. As I understood it, that was the point that was taken against you.
Well, I think they say that they would have brought judicial review because we wouldn't be to prevent us from arguing about the question of construction. What I understood to be what they are saying, what they did say, suggest anyway. So they suggested they might be able to bring a judicial review because somehow what we're arguing in construction is contrary to what was said in the past. Now,
so they wouldn't need judicial review for that. If it's procedurally unfair for you to take the point, they're allowed to say it's procedurally unfair in these proceedings to take the point.
Yes, but I think the reason that it's saying it's unfair is because Yeah, okay, it's maybe the same grounds that we've gone back on something we'd said before, but they haven't identified anything that was being said.
Well, yes, they say, you said, and you kept saying it, that this is just to be decided on ordinary contractual principles. On ordinary contractual principles, you can, they say, vary a contract as fundamentally as you want. It's still a varied contract if both sides agree, and that still means it's a contract with the original date on it, and therefore this expenditure is incurred under a contract entered into on that original date. That's their case.
Yeah.
And you're saying, though there's something in this wording of section 2981B, which means that doesn't work, even if they're right on the scope.
Well, we're saying that it has to be, although it has to be a contract, but it has to be a particular type of contract. And now, in fact, my learned friend agrees that it has to be a particular type of contract. So it's very difficult to see how we can take an objection to us saying it has to be one type of contract when they're saying it has to be another type of contract.
I'm very confused as to whether the point that's now being raised in, say you can't run this point, was raised in the Court of Appeal at all. Because, in paragraph 38, Lord Justice Lewison says that the LLPs reserved their position on the, as I understand it, on, is this right, on this argument? Is this the point, the first of the arguments? On the basis that it might not have been within the terms of the permission granted by Lady Justice Asplin. And they determined that issue, say it is within the terms.
Yeah.
And then get on with it. Apparently, no other objection raised to the point being run in the Court of Appeal on behalf of the present appellants. And you make the point in your written case that no objection to the argument was made in oral submissions before the Court of Appeal. So if it was run and decided in the Court of Appeal without objection, it's a bit late, isn't it, for the appellant to raise the point now?
I think that was our point.
Yes,
With respect, I don't want anyone to proceed on a false basis. First, my learned friend said, in answer to a question from my Lord Sales, that this point was argued in front of the upper tribunal. It is recorded at paragraph 120 of the upper tribunal decision, that's at page 186, that in fact it was not argued, and the upper tribunal would not let them argue.
So that reference again is paragraph?
Paragraph 120 at page 186.
Thank you.
So that's the first potential error of fact. The second error of fact is my learned friend's suggestion in answer to a question from my Lord Richards that there is no other objection made in the Court of Appeal to this, as opposed to it being within the permission. That, again, with respect, is wrong. I'll give you a transcript reference to that. Day 2, page 130, lines 22, and page 131, line 6. And again, if I give you a page reference to the bundle, page 1037 and 1038. I'm sorry to rise, I just don't want people to proceed on a incorrect factual basis.
Well, I understood it was argued in the upper tribunal. It was decided by the upper tribunal. They did decide, although they said that they were doubtful as to whether it could be argued or something along those lines. But it was certainly argued in the Court of Appeal and decided by the Court of Appeal. And I think Lord Justice Lewison records the fact that the objection wasn't raised orally. And my friend may say he was wrong, but that was certainly what Lord Justice Lewison said. If we look in the look at what the Court of Appeal said about it. Yes, paragraph 38 of the Court of Appeal at the end.
That's dealing with the permission to appeal point, isn't it? Paragraph 38.
Yes.
But that's not the point that is mentioned by Mr. Williamson on the transcript page to which Mr. Rabinovitz has referred, which we find at page 1037, I've only just seen, our submission is that if those points had been raised by HMRC in these proceedings at an earlier stage, then we would certainly have considered judicial review proceedings in relation to that. I don't know how that went on. Is that dealt with by the Court of Appeal in its judgment at all?
I don't think they specifically deal with it, but they certainly decide the issue.
I don't know what's happened to this, and Mr. Williamson having mentioned it, where the point has gone from there on.
It certainly wasn't expressly dealt with by the Court.
I think Mr. Rabinovitz gave us a further, that's the reference on page 131 of the transcript. Was there a further reference?
My Lord, that is the occasion on which it was raised, and I think I've given you the total references for where it was raised. The Court of Appeal don't deal with it because it's academic on the determination that they've made. But it was raised and it was there. The point was not argued. You see that at paragraph 120 at first instance. And if I need to address you further in reply on why it may be a legal point, but it's unfair and causes us prejudice, then I will.
I'd say I'm mystified by the reference at page 1037 to judicial review proceedings. I mean, this was, if it wasn't an issue, it was an issue in the tax case, yeah. So, anyway, no doubt we will be assisted further. But
well, I think what they were saying was not that they had any grounds for complaining, but that they might have grounds if they had known that this point was going to be raised. They might have been able to seek a judicial review.
But why?
Well,
why bother with judicial review? Why not just argue it out in front of the tribunal and then the court?
I don't know.
Well,
why, but that's what they
mystifies me. If you can't help us, we'll be assisted.
No, I think they were saying because we could have raised judicial review, or we might have been able to consider it, then you shouldn't hear it procedurally, because that would prejudice us. I think that was the argument that was being put forward by Mr. Williamson.
Right, but why couldn't they say it wasn't argued at first instance, therefore we are prejudiced that you're raising it now? Why talk about judicial review?
Yes, I don't know.
I don't know whether it would help you to rise. I don't like rises in this court especially, but we do say that. We do say it wasn't raised and we are prejudiced.
Yeah, no, I understand you're saying that. But
we do say that because there is a prejudice, and if I have to deal with it, I will. And we also say that we're prejudiced because of we would have raised this in judicial review, because there are 30 years of contact and communication between the commissioners and the construction world, in which they make clear that you can have a contract which is varied and it will still count for the purposes of these allowances. And if that sort of point had been taken, there was judicial review in these proceedings, as you know, separately to this claim, but also came before the upper tribunal. That would have been another point that was taken. I do hope that helps. I don't want to jump up again.
But it's all in your written case, I think.
It is.
And you are going to get a reply, albeit an attenuated one.
The only reason I rise is my Lord Sales was obviously looking.
I was mystified. Yeah, I find it useful to have my mystification addressed at that point.
I'm not criticising you for rising, Mr. Rivett, just to give you the comfort that you'll have your own time in which to
I do know that,
wrap it up.
I was trying to respond to you.
But, Monsieur, before we move away from the complexities of what was and wasn't run, what do you say about paragraph 120 of the upper tribunal?
It's 119 and
Page.
Sorry.
page 255 of the hearing.
Yeah.
Yeah.
Yeah. What they're saying there is that if we were arguing that contract meant something different from what it means in the general law, then we're not able to do that. And we're not arguing. I'm not arguing now that contract means anything different from the general law.
I thought that you were focusing upon the particular meaning of under a contract in section 298, which involves or may involve a departure from how the general common law might look at it.
Well, no, I think it's more a focus on what contract would qualify. We're not saying that it's not a contract. We're just saying it's not a contract that would qualify. So we're not departing from the general law and saying it's not a contract. The legislation applies to particular types of particular contracts, and that's what the argument's about. What kind of contract is it? As I said, my learned friend accepts that you do have to put a limitation on it. He's got his limitation, and we've got our limitation.
Yes, I see. Thank you.
But as I understand it, at that time, there wasn't any limitation being placed on the provision, and there wasn't in the Code of Appeals, I understand it, any limitation being argued for at all. So then, can we move on to clause 12? And I'd like to start with the recitals to the Golden Contract, which are on page 377.
377, did you say?
Yeah, 377.
Thank you.
And I'm not going to read them all out, but you can see, you read through those, that this is at the time of entry into the Golden Contract, the employer wished to obtain the design, construction and commissioning of any of the works option 1, 2, 3, 4, 5, 6. It then says in B, the contractor has examined the employer's requirements for each works option and has submitted proposals for carrying out each works option which the contractor is satisfied with in all respects meet the relevant employer's requirements, and which include the statement of the sum which the contractor will require, etc. Then C, the contractor has carefully examined the employer's requirements for each works option and is satisfied that they show and describe the works in sufficient detail to enable the contractor to prepare the proposals, etc. So we would say, insofar as my learned friend refers to the contemplation of the parties, what was the contemplation of the parties in entering into this contract is revealed by the terms of the contract itself, and the fact that this was a carefully crafted contract where both parties had looked closely at the various works options. In particular, the contractor had examined them and was happy with them. Those particular works options and those particular employers' requirements. There's no justification for asserting that the contemplation of the parties was any kind of building in the Newcastle area, in the enterprise zone, which I think is what my learned friend was suggesting. And you have seen the requirements for works option 1 are in appendix 14, which I think my learned friend showed you, which is in page 595. And they're set out very some detail. Now, I was then going to turn to clause 12, and I hope that the court has received a version, an amended version of clause 12.
They actually sent two versions, but I couldn't see what was the difference between them.
They seem to be the same.
Right, probably. Sorry? There is only one, yes, so they must be the same, I'm guessing. So that they simply show what the provision looks like, having put in all the amendments and deletions from the Golden Contract. And it's been agreed by the appellant, so this is accurate. With the addition, thank you very much, of a comma, I believe, that was missed out.
That's the document that's called CDC2 and CDC3, clause 12-24(1), etc., etc. Yeah.
So, yeah.
I'll just make sure I got the right document.
Yeah. Yeah.
Thank you.
So if we then look at clause 12, and the first point I'd like to make concerns the important issue of the proviso, which my learned friend places a lot of weight on. Now, as I understand the argument on this clause, as put in the case and orally yesterday, what is said is that we don't have to concern ourselves with the opening words of 12.1.1. They're not in any way limiting. But you can jump straight to 12.1.1.1.1, which I shall just call point 1 perhaps, and ask the question, is this an addition of any work? And if it's an addition of any work, then it comes within clause 12. That, as I understand it, is the argument. And that's why my learned friend showed you the cases about including allowing you to extend, etc. Now, the problem with that is, when you come to look at the proviso in 12.2.1, that only applies where a change which makes necessary an alteration or modification of the design of the works. Now, my learned friend's case is this is not a modification or alteration of the design of the works. It is something different. It is an addition of a work. Because if he cannot say this is a modification of the design of the works, he accepts that. So it is not possible, logically, if this case is correct, to rely on the proviso. And indeed, actually,
just on that, I thought that the argument was, because of the width of the power to add work, that if you add work, you change the works. And so you do get into alteration or modification in the design of the works.
But as I understood it, he accepts that modification of the design, quality, or quantity of the works would not cover, that phrase would not cover what they did, because they weren't modifying the works. They were changing it so that it wasn't the works, it was something else. So I understand it.
My understanding was that the point that was being taken was partly this linguistic point, that all that the change is it's an change of the employer requirements, and that was regarded by the reports below as not encompassing a change to the works. But his case was, well, if you can change the employer's requirements and there appears to be no limit on the amount of change to the employer's requirements, then you must impliedly also be able to change the works.
Well, I'm not sure that's exactly how exactly it was put, but
well, that's how I understood it.
Yeah,
okay.
That's how I understood it as well.
So what we say is that the works have to remain, and that's what we said throughout, and what we decided. Right. The works have to remain.
Your case is you can change the employer requirements, but not so much as that actually means a change in the works. Is that your case?
It is a change in the works. It's a modification. It can be a modification of the works, but it can't be such that the works don't exist anymore, that it's something other than the works. That's the point. Because you're not modifying the works if you are producing something that's not the works. Capital W works.
So it doesn't extend to completely different works?
Yes, which is not the works. Yes, another lot of the works. Yes. Yes, exactly. But that's the argument that has been accepted below. And I'd understood my learned friend's argument to be, having read his case again this morning, we don't have to worry about the limitation in the opening words, because including means that you can look at 1.1 Article 1.1 as a sort of freestanding provision. And we come within that, there's an addition of any work, they say, and therefore we're allowed to do it. As I understood, that was it. Otherwise, I can't see how it gets off the ground, because if you accept that you have to be modifying the works, then you can't possibly be modifying the works by producing something that isn't the works. No one would say that. If that is my learned friend's case, then it's hopeless. But I understood it to be a more subtle case than that, which was that on the basis of these authorities, that you don't have to. Remember, he was saying, well, if it says animal and it's got a list of things including computer, then computer, you can say it's a computer. You don't have to look at whether it's an animal at all. That was his example, I seem to remember. So I understood him to be saying, we just rely on 1.1. We go straight there. We don't look at the opening words because we can't get within those. But the problem with that is that you have to get in within those words to be within the proviso in 12.2.1 for obvious reasons, because it is assumed by the draftsman that you have to be within those words to begin with. But my point is that if he's right, then the proviso doesn't apply to this. And indeed, there was no question factually of the contractor being asked to consent to what happened, or to give his consent. So that didn't happen. Possibly because it was never thought that this proviso would apply to this situation, because it is not a change, it's not an alteration or modification in the design of the works, on any view. And that's certainly what was it.
Sorry,
So that's what happened.
I mean, we saw that the change orders purport to be served under Clause 12. But why do you say there was no consent to those change orders?
Well, they weren't asked.
Insofar as if they were under 12, then it would have been with the consent of the contractor.
No. First of all, not everything under 12 requires consent. It's only a modification of the design. If you change, for instance, the quality of goods, you don't have to get consent for that. It's only the if you like, the largest kind of thing that could be done. I think essentially the biggest thing, changing the design, then you need consent. But if the employer is simply changing the type of bricks he's using or something, then he doesn't need consent for that. But secondly, they wouldn't need consent for this because they're not modifying, or the consent provision wouldn't apply because they're not modifying the design of the works. They are substituting a new work, capital W works, which is a different thing. I mean, if the argument was this is a modification of the design of the works, then my learned friend wouldn't have to look at 1.1. He could just go straight to the opening words and say, well, as a matter of construction, this is a modification of the design of the works. But I would suggest that's a hopeless argument. Because if you modify the design quality or quantity of the works, the works have to remain. That is totally clear. So we say this point about the consent is simply misconceived. And I don't understand it to be a point that was raised below. I can't remember it being said that consent was required for this, or indeed was sought at any point. I mean, the other problem would be it does look as though you have to have consent before it would be a valid change if the proviso applied, because you cannot effect a change without the consent of the contractor. Actually, that should be contractor. I think I've noticed that type. in my version, but it's been corrected in yours. So anyway, I just want to make clear we don't accept that consent was required, and if it was, it wasn't given. Now, my other friend will no doubt he will say, well, they built the building, but as we shall see, a lot intervened between this and then building the building. And one cannot assume that they consented when they weren't asked to consent and they weren't told that they weren't suggested to them they had the right to.
I mean, that may be literally true, but it has a whiff of unreality in circumstances where both the developer and the contractor are newly created shell companies owned by the same person.
That's true, but I think you do have to respect these things in these tax schemes, because otherwise you could just concertina everything and just say, well, everybody obviously knew what was going on, everyone's agreed to everything.
I think you would say if you live by the sword, you die by the sword, wouldn't you, Stuart?
Yes, well, yeah, exactly. You have to, yes. You have to go through the motions, I think, in these schemes. So if we then turn to the construction itself of the words, now we say that the words in 12.1.1 delineate the change in the employer's requirements which can be made under 12.2.1. And the list after the word including are, we say, clarificatory examples of items which fall within the general words. And in my submission, this is not at all unusual to provide for general words and then to provide a list in order to clarify in case there's any doubt. And the structure of it is to deal with, first of all, labour, essentially, work, and then to deal with materials. So most contracts will involve both labour and materials. So the labour is dealt with in the addition, omission, or substitution of any work. Now this must be work that is already provided for in the works, capital W, because you can't add, omit, or substitute for something that doesn't exist. So the work referred to must be the work under the works. I think that must be right, although it doesn't say that, and it may be that they chose not to say it just because it sounded a bit awkward to talk about the work under the works.
Isn't it the work in the employer's requirements?
Yes, which form the works. It's the work that's already there in the employer's requirements under the works, that's right. And similarly, they would deal with the materials in 1.2. Now, it's interesting that my learner friend doesn't rely on 1.2. He only relies on 1.1, as I understand it. He only relies in relation to labour, not in relation to materials. It's difficult to see how you could get a completely new building like this without altering in some way the kind or standard of any of the materials, goods to be used. Can't seriously be the case that they use exactly the same materials to build this other building. That would be an amazing coincidence. But all my learner friend relies on is being able to alter the labour that's carried out under 1.1. As regards the authorities, I think all I can say is that they make it clear that Where there's a word including, it's a matter of construction in any particular case. So they don't take the matter any further.
Well, what do you say it means? And
We say what clause 12 means.
what the word including means?
Well, we say that that's introducing, as I said, a clarificatory list of items that might or might it may be doubtful whether some fall within it, or it's just making clear what the kind of thing it is that falls within the general words. And as I say, it's very common in contracts and in statutes to have this kind of list. It's also very useful in applying the used in generis rule to know if you have an item that's uncertain, you know what kind of items are intended to be within the general words. If you just had the general words, then that could cause more difficulties. That's the way that these things are often structured. So they're just making it clear that in doing this, you can do these things, and possibly things that are similar to those. You can add or omit or substitute any work, for instance. And I suppose it makes clear that it can be any work, so there's no limit on which work you can add, omit, or substitute.
But I thought there was a limit on what work we could add.
What type of work? I mean, what kind of things you could modify? And I say there's a limit to what you can do, because what you're doing this for the purpose of modifying the alteration or modification of design, quality or quantity of the work. So all of this, you must bear in mind the opening words. The general words is what governs. Why is that? There are a number of points supporting that. Well, first of all, it's clear that, as I've said, both 1, 2 and 3 all must refer to things done under the works. 2 and 3 expressly say so, but 1 must be work under the works. Everywhere else in the contract, of course, the works are carefully and fully delineated. And as I've shown you, the contractor has considered the works options, confirmed they were happy with them. In our submission, that entire structure would be rendered nugatory or pointless by the appellant's construction, which is, despite the fact that the contractor has looked at all these options and had considered them and studied them and been satisfied that they can do them, the employer could require them to do something completely different. Then there's also the point that the change in the employer's requirements, even if you're able to do that, doesn't change the contract sum which you're required to pay under the contract. The obligation to pay the contract sum is provided for in Article 2 of the contract, which is on page 378.
Page, again?
378.
Thank you.
And that is defined in clause 1.3 of the conditions on page 383.
Forgive me, I was just behind you. So on 378, we're looking at Article what? Sorry.
Article 2.
2. Contract sum, or such other sum as should become payable.
In the manner specified in the conditions, yes.
Yeah, right. Sorry, and then it's the conditions of payment.
And then the contract sum is defined on 383. These are the sums stated in Appendix 14, 15, etc. But this is not part of the employer's requirements. But the point I'm making is that that's not part of the employer's requirements. What can be done under the contract is an increase in the contract sum in certain circumstances provided for in clause 12.3, which is where there is a variation, which is on page 405.
Sorry, isn't it in the composite document?
It's in the composite document. Yes, I'm sorry. You're absolutely right.
That's
Yeah.
right.
Sorry,
Yeah,
I
you go to the page as
read these
well.
notes. Yes, it's 12.3a, which is added in.
We're at 12.3a, or the whole of 12.3a, is it?
Yes, the whole of 12.3a
Yeah.
I see,
is
yes.
added in.
What's the... Sorry, I'm getting a bit lost. What's the point you're making here?
Well, the point I'm making is that you cannot, under clause 12, you cannot reduce the contract sum, which is exactly what they purported to do in this.
I'm sorry, I see. That's right, I missed that.
What you can do is provide for modifications, and then the contractor can claim under 12.3a, can claim further payments if they wish, if they're able to, if it causes them more cost. But what you can't do is change it, is alter it by what you do under 12.
So you say the pricing structure is one under which the only adjustments that can be made as a result of a clause 12 instruction are adding on
Yes.
additional sum in addition to the price already agreed for the performance of that option.
Exactly.
And that's inherently hostile to an alteration which in substance creates a wholly new option that hasn't got any real tentacles attached to an earlier option.
Yes. But what more than that, they purported to actually change the contract sum in this case downwards.
To what?
To change the contract sum.
Downwards?
Sorry, downwards. Yes.
Yes.
I see. So, and one would assume that if they wanted to make a clause 12, if the employer wanted to make a clause 12 change, which they knew would actually save the contractor money, they can't say, we're going to make you change this and we're going to pay you less. They have to pay them the same, and they assume that the contractor will not be happy to consent to that because it increases their profit. But you say that as this change order in fact reduced the amount for the work option, then it can't have been under clause 12.
Well, yes, and there's no provision for that. And it does two things, really. It shows you the scope of clause 12, because you would expect, if there was the ability to change it fundamentally to a completely different building, you'd expect the ability to alter the contract sum commensurate with that. But there isn't any provision for that. But I also make the point that they did purport to do that in this case. But of course, it makes perfect sense that you can reduce it because the contractor has agreed to take on this work for a contract sum. You can't be in the power of the employer to. You wouldn't expect to be in power of the employer to say, "Oh, actually, I don't want you to do that. I want you to do different things for less." And my final point is that on the appellant's case, clause 12 must also be wide enough to change the basic nature of the golden contract from a single building contract, a contract to build a single project building, to a multiple building contract. And this appears to be what the employer purported to do in change order number 1, which you'll find at page 648. As I understand it, the words right at the end, further change orders may be issued in respect to the building within works option 3 or otherwise, in accordance with the contract. That is what is relied upon for the ability to issue further change orders, that is number 2 and number 3, to build other buildings. Somehow, this contract must have been changed from a contract to build one building out of a menu to a contract to build limitless numbers of buildings, presumably. Now, the appellants give a lot of space in their written case and still, I think, maintained it in oral argument to knocking down the idea of that there is an implied limitation in the opening words of clause 12.1, that the works must remain after the alteration or modification in question. And we say that's not an implied limitation, that simply is a limitation that comes from the words that are actually there, that it has to be a modification, alteration, etc. of the works. And there's no need to imply anything in.
While we're looking at this point, the upper tribunal concluded, and I don't think this is challenged, that the golden contract wasn't just a pure set of options, that there was an obligation to choose, you would say one, they may say one or more options.
No, I think everyone says under the contract it was to choose one.
And where is that's what the upper tribunal said, and it's not been challenged, but I'm quite interested to know where in the contract one actually finds that definition of the obligation on the developer and the constraints around it.
Well, my learned friend who...
I mean, I don't mind if I get that answer later on when somebody's done the burying into this extraordinarily difficult to understand contract, because we haven't had that clause produced in a appropriately amended form.
Yes. I'll just tell you what I'm told, and you can look at it. It's clause 23A, point 2, which is on page 423.
Thank you.
I think it may be I agree with you. I always find this slightly puzzling, but
well, that's just an.
I think it's the word "shall." I think it's the imperative words.
Yeah, I mean, it appears to impose an obligation on the employer. Although,
at what point the contractor could complain, if ever, about this?
But
yes,
whether it's only one option or more than one option depends on whether the singular includes the plural in 23A2, doesn't it?
Well, no, because I think whether it's one or more comes from the basic provisions of the contract, which provide for it being one. There's a list and there are alternatives.
Yes, it quite often says, to be clear, it's works on option 1 or works option 2 or works option 3.
Exactly. Yes. Yeah. And I think this is common ground. I mean, I think even being the statement of agreed facts that it's one. Yes, it's the definition of works on page 386 and 387. It should be either works option 1, works option 2, works option 3, works option 4, works option 5, works option 6. So that's where you get it. It's a single works option. And it may be 23A where you get the idea that they have to choose one at some point. Which they did, in a sense, in a very artificial sense, but they did. In the appellant's case, they do raise an argument based on clause 4.2, which is a new point. My learned friend didn't develop it at all. We've answered it in our case. The preconditions for that clause simply didn't happen. so it didn't apply. I think the argument is it could be applied by analogy. We don't understand that argument, but we've certainly dealt with it as far as we understand it in our case. My learned friend didn't say anything more about it, so I'm not going to say anything more either. So we say, for all these reasons, that it's actually quite plain that the purported exercise of clause 12 was not within the scope of the provision. Now, where does that leave us? And we say the first thing to understand is that, assuming we're right that it's invalid, is that everyone believed it was valid at the time. So I think it's quite clear that all the parties acted in the mistaken belief that it was valid. And the £54 million that you've had mentioned payment was made on that basis on the 1st of April. Can I just go back, though, looking at the chronology, to the first notice to proceed, which was given on 20th November 2009, which resulted in the construction of DC1, and we know that was built on site C, which you can see on the plan on page 978. And we understand that DC1 was completed to shell and core in August 2010. That is something that appears in footnote 51 of the appellant's statement of case. So there are two stages to this. It would be built to shell and core first, and then they would be seeking a tenant. And when they found a tenant, then the fit-out works would take place to some extent in accordance with the tenant's requirements, because they wouldn't know it until then. And so at that stage, there would be a further contract. There'd be further building works have to be carried out. That hasn't happened, certainly as I understand it, not in relation to DC2 and DC3. I don't think they've found a tenant for either of those yet. So we would say at that point, the golden contract, which provided for a single works option or a combination to be selected, had been exhaustively performed, in the sense that the works option had been selected, and indeed there had been some performance. Then the second notice to proceed also elected for works option 1, and we can see that it's on page 241 of the bundle. Oh, that one, yes, sorry. Sorry, that was a reference to the opportunal decision. It's on page 650. And you can see the form of that. It also elects for works option 1. And for the sum of £54 million, and that's the reduction I was referring to from the amount provided for in works option 1. Which
what was the amount provided for in works option 1? Where do we find that?
I think you can find that on page 58. 583. Page 583, which is Appendix 14, it was 102,500,000.
So could you just remind me, work option 1 was under the terms of the Golden Contract, the construction of what, where?
Well, you can see it on page 583, my Lord. As to where. Oh, yeah. Yes, there is a shorter version on page 387, the definition of works option 1.
Okay. Did you say 387?
387, yeah.
Thank you.
8-inch board and site C.
Right. Hold on. So it's an industrial unit
Yeah.
on site C.
Yes.
Right.
Yeah. So you can see there's a certain air of artificiality in electing the second time for works option 1.
So change order 1 referred to works options 1 and 3.
And 3, yes.
So work option 3 provided for, well, no, I see that here
The next page.
on the next
Yeah.
page. So that's business park on site A. Okay, well, that's the, yeah.
Yes. I'm not quite sure why they elected for 1 and 3, but because they in fact only built something on site C. But anyway,
Right.
no doubt there was a reason. And I had inferred, maybe wrongly, that the reason for the alteration to allow the exercise of 1 and a combination was in preparation for number 1 in some way. Because under number 1 they elected for the combination that they had just recently amended to allow for. But I don't think it matters. But as I say, there's a certain very large air of artificiality in 2011, then electing for works option 1, which at that stage is impossible to perform completely because the site has got a building on it and presumably has also been leased to the owners in respect of CD1, DC1.
But with change option 1, which you say they purported to be exercising the permitted combination of works options 1 and 3, they then had a separate employer's requirements document, which presumably described what needed to be done to achieve what they were describing in works in the change order 1.
Presumably, yeah. Yes, I don't know whether that one's been lost as well. We haven't got to the litigation of that particular scheme yet.
You can assume that the employer's requirements, for change order 2, which purports to be related to works option 1, but had employer's requirements which must have looked different from Appendix 14 because what they built was different.
Yes. Yeah. I guess they must have, and whether that was in the change order or in the development agreement subsequent, which they undoubtedly must have had as well, presumably, some kind of a development agreement. It must have been different because they built a different building.
And DC1 is built, did you say, on site C?
It's built on, yes, you can see on the, it's actually on the plan in 978, it tells you where DC1 is.
Right.
It takes up almost virtually the entirety of site C.
Right.
But it doesn't go beyond, I mean, it just is on site C.
Right.
If you look at the plan.
So you say there are effectively two reasons why that notice to proceed is bad. Firstly, because it's based on a bad change order 2, and secondly, because you can only have one notice to proceed, and it's the second one.
Yeah, exactly. Yeah. So that's the, if you like, the exhaustion point of the contract.
Yes, which we're going to get to presumably quite soon.
Yeah. Yes. Now, we then come to what I would submit is quite an important point, that there was no express agreement between the developer and the contractor varying the golden contract. This case is different from, like I suggested earlier, different from all the other cases that you've looked at where there was an agreement between the parties to vary. And the question was, what was the effect of that agreement? Was it a variation or was it a new contract? And did it rescind the earlier contract? But here there's no express agreement. It's never been the LLP's case that it was expressly agreed variation. I think what Mr. Williamson said in the Court of Appeal was that the agreement came from the invalid instruction combined with the fact that they built the building subsequently. My understanding is my learned friend's position is slightly a bit different in his submissions. But what I understood him to be saying was that you could assume from the invalid instruction, or you should rectify it or cure it by a valid agreement. So you should assume that there was a valid agreement. Although they did it the wrong way, that you should assume they could have done it the right way. And he relied on the cases in relation to discharging, if you remember, contracts where there had been a repudiatory breach. I'll come back to that. But this kind of approach, while we would say, and I'll say it's wrong in law, but it's also extremely concerning as far as the revenue is concerned, that you can say in a tax scheme or in any other scheme that you failed to do it properly, but you must be assumed to have done it correctly. Or we must assume you've done what you would have to have done in order for it to be done correctly. And they base this entirely, as I understand it, on the intention of the parties. The intention in the sense that the parties must be taken to have intended that the tax scheme would work. In other words, that they would do the right things and achieve the right result. And I'll come back to this, but this is a very difficult concept to pin down. What exactly?
You don't always have. I mean, in terms of what constitutes a variation of a contract, it must be right that you don't need an express variation to achieve a variation. So, like any other contract, it can be done by conduct,
exactly,
and implications, and so on.
Yes.
So, isn't the case being put against you that that's effectively what we here have? We have an implied, if you like, an implied, agreed variation.
Exactly, and I think that's exactly right. Implied contract, implied agreed variation. But the question is why you would imply it in this particular case. And I'm going to come on to develop this, but we would say you don't have to. You'd only apply a contract if you have to imply it, if it's necessary to imply it. You cannot simply say, well, we've done it wrongly, but we could have done it correctly. They say we could have done it correctly. Therefore, we'll imply a contract because that will mend the problem. And that's illustrated.
The point that once Clause 12 is knocked out, what they want to achieve in terms of a binding commitment to build the building and a binding commitment to pay for the building of the building is achieved equally whether it's a new contract or a variation of the old contract. And you say it's very concerning if they're allowed to say, oh, well, it's a variation of the old contract because we wanted to get the tax relief.
Oh, yes, and that is the way that we get it. I mean, one of the difficulties with this is, my learned friend says, this is an objective, we're looking for the objective intention of the parties. The objective intention was clearly to get the tax relief. So we must assume that, we must say that this was their intention was that this would be a variation rather than a rescission. But does that work the other way around? If exactly the same facts, the tax relief had been, you required a rescission rather than a variation to get the best tax result, would the answer then be rescission? I mean, it seems to follow logically from what Leonard Friend says that whatever is the best tax result, that's what the answer is going to be on exactly the same facts. And then, of course, the question arises, well, supposing the position is not clear, because sometimes happens, we don't know how you get best tax results. That may be part of the litigation. We may be litigating about whether you get them for a rescission or a variation. I mean, and supposing the parties got it wrong, supposing they thought it had to be a rescission, but in fact it had to be a variation. My learned friend says it's objective, must be objective. It doesn't matter what the parties actually thought. So it seems as though even if they got it completely wrong, then you would assume that their intention objectively must be to do the right thing. That seems to be where this case goes, and that's what's really, that particular feature of the upper tribunal decision is very concerning as far as the revenue is concerned, because obviously there are lots of situations where even where whether it's a variation or a new contract makes a big difference in tax.
Well, it also with the variation of trusts, it often makes a difference whether the changes to the trusts are a variation of the trust, in which case the trust then still predates a tax change, which only applies to trusts settled after the date, or whether it is a resettlement of the property, in which case it goes into a different tax regime. Yes.
Yes, there are a lot of situations in tax, and no doubt outside tax, where this makes a difference. So I'm certainly making that point, but I was also making, another point here, which is a factual point that one cannot, quasi-factual point, picking up what Lord Burroughs was saying, that you cannot imply a contract to vary in this particular case. And you can't simply imply it out of the failed instruction. I think that must be clear, because we have a case in there, the bundle Beasley and Hallwood Estates, where you may be familiar with, where there was an invalid exercise of an option because it hadn't been registered, or I think as a land charge or something. And the question was whether you could spell out a valid agreement from this invalid exercise of the option, and the answer to that was no, you couldn't. So there has to be something more than just the invalid instruction. And the something more that had been relied on below was the actual building the building. So it was said, well, there must be a contract to build the building. And that's where it was in response to that argument that the revenue rely on the sale and development agreement.
But isn't the critical point the payment of the 54 million on the 1st of April? Because it's from purposes of the statute, it's the seeing caring of the expenditure which is important.
Well, at that stage, it wasn't paid under any contract.
Well, it certainly wasn't paid under the SDA.
And it certainly wasn't paid.
But it's hardly a gift, is it?
Well, it's a payment based on the mistaken belief that they were liable to make it.
I see. Under
the contract as varied by the instruction, which was in fact not valid. So at that stage, if the contractor had got woken up on the 2nd of April, he could have said, look, or the developer had woken up. They both woken up. They could have said, we've made this payment under a mistake. We want it back. Let's start again. So at that stage, it wasn't paid under any contract, because you can't say that it's paid under the contract, under obligations which haven't been validly created.
I mean, of course, it's being said against you that's one possible analysis. The other plausible analysis, arguably, is it was paid under the very contract where the variation is implied from what the parties have done. They've both paid the money and bills.
Well, but generally, where parties have proceeded on a mistaken but common assumption shared between each other that what they have done has been legitimately done under some prior structure, that normally gives rise to convention estoppel.
Yes.
Which I'm thinking of IRC and bench dollar, I think, vaguely. And in that situation, as between the parties, you don't have to imply a variation to the contract or anything of that kind. No. They are stopped, if you like, from saying it wasn't done validly under the original contract. But I'm not quite sure what consequence that would have for compliance with a statutory requirement, which says it has to be done under a contract.
Well, it wouldn't. In my submission, it wouldn't be done under the contract if the reason why they were able to keep it was because of an estoppel, because that's a matter between the parties. It's not a matter of the contract. That's just one of the parties is not allowed to deny, for instance, that he's liable to that it was paid.
When the 54 million was paid on 1st of April, there was no doubt what it was being paid for, is there?
It was being paid for
the work that was specified in the change order.
Yes.
So why would you? I mean, isn't the issue really at that? I mean, isn't the choice really between either implying a variation of the existing contract or inferring, like implying, the creation of a new contract on the 1st of April?
But we would suggest you don't have to do any of these things because you have a contract on the 4th of April providing for the building.
This is the 1st of April.
Oh yes, on the 1st of April.
I mean, I know you say that,
I
understand why you say it was paid, as it were, under a mistake, because they thought they were doing it pursuant to the existing contract. But if that's a mistake and invalid, is it really the result? Well, there's no contract at all at that point.
Well, no, but no one on that date.
I mean, they intended to be.
The contractor wasn't.
The contractor hadn't done anything. The contractor hadn't done anything.
It paid.
They weren't bound to.
No, the contractor receives the money. So all three steps, that's the change order and the notice to proceed and the payment, come from the developer.
Yes.
And they go to the contractor, and the contractor just sits there with an ever-widening smile on his face.
Yes.
That smile being of itself of no legal consequence.
I find it very difficult to understand how the contractor can accept the money.
Yeah,
they're going to do the work.
I'm not sure what they did by way of acceptance.
By accept it, you mean not send it back immediately?
I do, yes. A bank it. Oh, that's got 54 million in the bank.
Well, that's because
they were on holiday.
They were under the same mistake. Because they were under the same mistake. They were under the same mistake at the time that they were.
There's no dispute. I mean, there's no doubt that they all intended for the building to be built.
Yeah. Well, yes.
To sort of throw our hands up and say, well, there's no contract, seems a counsel of despair at that.
Well, it can't be unjust enrichment because they're the ones who've been they've been. I mean, if they'd then not done anything, they'd said, "Oh, thanks, we'll have the 54 million and we'll go on several round-the-world cruises."
But if they sent the money, if they had sent the money back, I mean, if they realised they got it and they sent it back, they wouldn't be in breach of anything.
Well, they may be. I'm sorry, that's just to pose the question again.
Yeah.
The question might be at what point would they become liable to build the building if they did nothing? The fact is, it's all academic because they entered into an agreement expressly on the 4th of April to build the building. So there was no question.
That doesn't presuppose that if there was a pre-existing contract that was set aside.
It's not, but
Does the SDA
it
offer
explains
to set
why.
aside the golden contract?
Oh, no, the SDA also worked on the assumption that this had been a valid.
Yes, so the SDA was not intended to create a new construction contract, was it?
It wasn't intended. No, it certainly.
Well, it wasn't, because you accept that the golden contract was still there.
There was a contract, yes. It was intended. I think the intention, you would say, was that there had been a variation, they believed, a valid variation in the golden contract, requiring the building of what was specified under the change order. What they needed was a more detailed agreement, which is what the SDA did, as to how they were actually going to do that, because there had to be, well, you'll see in the SDA, there are lots of provisions about how you're actually going to have the building built, subcontractors, etc. So they needed all of that stuff to be entered into. The question is, well, one question might be, were they acting under any contract when they paid the £54 million? And we would say, no, they weren't acting under any contract then. That 54 million became, if you like, attributed to the contract once they've agreed validly that they're going to do it. But that didn't happen on the 1st of April. There's no question of that. There's nothing happened on the 1st of April, or.
You said it was attributed to be consideration under the SDA.
It would, yes. I mean, what would happen is that they wouldn't, the developer wouldn't be able to ask for the money back. And I'm not suggesting that for a moment.
Did the SDA provide for payment of the 54 million?
No, it recognised that it had happened. Because by that stage it had happened.
Yeah, but sometimes you see contracts that say the consideration for this contract is X million, and we hereby acknowledge that the X million was paid a week ago.
Yeah.
And that counts as the consideration under this. We've already received the peppercorn.
Yes, I don't think it said, well, we could look at the SDA, but it didn't say that expressly. No. It recognised that the money had been paid, and of course that was part of the financial whole arrangement.
Yes.
And then it provided for a lot of the financial movements of money.
Yeah, so
it provided for the owners, who are the LLP, to pay 153 million to purchase the benefit of the golden contract. So clearly, they all thought at that stage that the golden contract had been altered into the form. That was the whole basis of the SDA. Was that happened? Absolutely. But my point is not that. My point is that there's no need to imply a contract to vary the golden contract, because you've got the payment of the money, you've got a contract in the SDA which provides everything you need to build the building. So there's no need, if you're asking a question, do you need to imply a contract from the circumstances?
Your analysis leaves this 3 days of sort of gift or money paid under a mistake.
It was paid,
or law. It doesn't really matter.
I mean,
that's what you left with.
I mean, yes, just to follow up, I mean, it strikes me that the question we have to ask is it necessary to imply that contract on the 1st of April?
Yeah.
So it's not it doesn't seem to me any help to have that, to say 4 days later there's another contract, because so what? We need to know what the position is there. And I think your answer to that is there is no contract.
Yes. Well, I think it is relevant that the SDA was entered into on the 4th, because everyone knew it was going to be entered into. I mean, clearly it would have been being drafted for months before. If you look at it, it's an enormously complicated contract. So it wasn't a surprise. Everyone knew that they were going to enter into the SDA.
Yes, but no one supposed it was being paid, as it were, on account of an agreement.
No, of course. No, nobody understood that.
So it would be rather odd to imply that, given that it's always possible that for some reason the SDA was not entered into.
Yeah. Well, if it wasn't, then they have to pay the money back, because the development couldn't take place. Because you needed the SDA. It was a crucial part of the whole thing. For one thing, it was how the money came from the members, or the LLPs, into the scheme. So it was under that contract.
Suppose something had happened in those 3 days, which meant that actually none of this could be built. The enterprise zone was discovered to be built over some...
Yes.
So the whole project had to be abandoned. I suppose they would get the money back either as paid for a total failure of consideration if there was a contract, or paid under mistake, or they'd get it back.
Frustration or something.
Well,
who knows? Yes. But it's not necessary to imply a contract on the 1st of April to achieve any commercial purpose here. It's just completely unnecessary. Either the STA is entered into, in which case it all goes ahead, or it's not, in which case it's not going to go ahead, in which case, presumably, they pay the money back.
Well, a convention estoppel would have solved all the inter-parties problems.
Yes, exactly.
From the moment when the contractor did something that crossed the line.
Yes,
I'm not sure whether just sitting on the money for 3 days would be crossing the line, but the moment he lifted up a trowel and laid the first brick, then he probably would.
That's a long time after all of this.
right, but your overriding point is, well, there are a dozen or so ways in which this could be interpreted, but what's illegitimate is to say, well, the one we choose is the one that gives them the tax relief because that was what they were intending to get.
That's certainly a point, but my other point is that we're not arguing here about commercial matters. There's no question about there being any problem commercially with any of this. It's a very sort of highly technical.
All it's doing is delaying lunch, Mr. Ewart.
Yes, I was thinking.
Slightly overdue.
Could I just ask?
Yes.
Mr. Ewart, just going back, I'm trying still to understand the scope of the arguments that were presented in the Court of Appeal. I don't think we've got the skeleton arguments that were prepared for the Court of Appeal. Would it be possible for those to be sent through with short adjournment?
Yeah, sure.
Thank you.
Yep.
Thank you.
2 o'clock.